Good afternoon. My name is Darby Dickerson. I'm the Dean at Texas Tech University School of Law. I'm very pleased to be joined here this afternoon with Justice Phil Johnson, who is an alum of Texas Tech, doing an interview for the State Bar of Texas, the project where they are interviewing all of the living former justices of the different courts of appeals. Good afternoon, Justice Johnson.
Afternoon, Dean.
Thank you for being here with us.
Pleasure.
Could we start out by you giving us some of your background, where you were born, where did you grow up, where did you go to school and to college?
Sure. I was born in Arkansas. My dad and mom originally from Arkansas up in the northwest corner. He was in the service in World War II, and she went back home while he was overseas. Then when he was separated from service, they stayed and lived in that part of the country. But then he was recalled for the Korean conflict, so he decided to stay in and make a career of it. So we moved around a bit, and I've lived in San Antonio at Randolph Air Force Base, ended up in West Texas because he was transferred to Reese out here, and ended up graduating from high school. Started school at Texas Tech and ended up graduating from Tech, went into the service myself and was transferred back to Reese, and I separated there. So attended law school here, and that's how I'm here.
You had a very distinguished service career yourself. Can you tell us a little bit about that?
I graduated from Tech and went through pilot training in Arizona, and then served a tour in Vietnam. And after that was transferred here to Reese to train student pilots, which I did for several years before I separated from the service. And when I separated, I started right into law school.
At what point did you decide you wanted to be a lawyer?
Well, while I was in the service, I had planned on making it a career, but circumstances change, things change. My wife and I decided it would be good just to settle down and not travel as my family had with my dad. I enjoyed my time in the service, but we decided to settle down, so I needed to find some way to support a family. I had a younger brother who graduated in the first class here at Texas Tech, and he encouraged me to take a look at it, consider it, and I did, and Tech was good enough to accept me, and that's how I ended up at Tech.
Great. Tell us a little bit about your legal practice. Where did you start right after law school?
I started at the firm I ended up with, a firm of Crenshaw, Dupree, and Milam here in Lubbock. They gave me a job trying lawsuits, and so that's what I ended up doing for over 23 years. Stayed with the firm and practiced. Our practice was more of a regional practice, Amarillo, Lubbock, Midland, Odessa area. So I did mostly of that. Although in a community the size of Lubbock, you also do a little of everything. Mm-hmm. You know, you have friends come in, they have family law problems, you have contracts that you do, but primarily I had a civil trial practice, board certified in personal injury and civil trial, and that's what I did up until I left the practice to go on the bench in Amarillo.
Were there any particular cases that were inspirational or challenging to you in your practice as a litigator?
Well, just about every case that came in the door, people had tried to work it out. As most litigators know, they try to work it out before they go hire a lawyer. So by the time they get to you, it's pretty well decided that you're going to be in it for a while. And all of them, to me, were interesting. Some were a little more challenging, but interestingly, the more challenging ones I thought were ones involving family members. For example, you get family members upset with each other over an inheritance or in a business transaction, and it's not like a regular lawsuit where it's a matter typically of money or you're going to try to get something straightened out, because there are emotions involved in it, and those were challenging. Those were the more challenging ones, I thought.
Can you tell us about some of the people who inspired you during your career as a practitioner?
Certainly. I was fortunate to go to a law firm where the partners and the members of the firm believed that public service was important, participating in bar activities was important, They encourage lawyers to do it, to become active in statewide organizations, and so that was probably very fortunate for me, because Jim Milam, who was the head of the firm, Crenshaw, Dupree and Milam, Bill Moss, a lawyer I worked for directly, was instrumental in guiding me. Joe Nagy, former president of the state bar, John Cruz, just lawyers who, John Cruz has received numerous awards for doing pro bono work here in the area and statewide. So lawyers that I feel were not only good lawyers, but good people, and I was fortunate.
You told us that you did primarily litigation. Did you handle appeals while you were a practitioner?
I tried to every now and then, but I was fortunate enough to have a good litigation practice, and when judges call you to the courthouse, other things tend to get shoved back. So we had an appellate specialist in the firm, Cecil Kuhn. Excuse me. And so what would ordinarily happen is I thought, well, I need to go through this to make sure I've just keep my familiarity up with the whole process. And typically, about the time the brief was going to be due next week, I would go to Cecil and say, Cecil, we have a time problem here on this appeal. So he would jump in and bail me out. I argued several cases before the courts of appeals in Amarillo, a couple before the Supreme Court, but I did not typically participate in the appellate process just because of the nature of the practice and the way our firm handled it.
You went from practice directly to an appellate court. Can you talk to us about when and how you started thinking about becoming a judge and what that process looked like?
Well, I had early in my career, about halfway through my career, I had been approached about maybe a trial judgeship. But at that time, I just did not think I could financially do it, so I did not. But then later in my career, after I'd practiced a while, my family and responsibilities were a little different. A bench was going to come open on the Court of Appeals in Amarillo, and I had talked to some attorneys who had encouraged me to look at that. I did, was fortunate enough to be elected, and then Justice John Boyd, who was Chief Justice at the time, retired, so I was fortunate enough to be elected to that, and so that's how I ended up where I was in Amarillo.
Who appointed you to the bench?
Well, I was appointed to the Supreme Court by Governor Rick Perry in 2005. And so that's an interesting process in and of itself.
So were you elected to the Court of Appeals the first time?
Yes, I was elected, and then I was elected Chief Justice, but I was appointed to the Supreme Court.
Thank you for clarifying that. Who were some of the justices on the Amarillo Court of Appeals when you served?
Well, the current Chief Justice, Brian Quinn, was on the Court of Appeals. Chief Justice at the time was John Boyd, who still serves as a visiting judge there. He's retired. And then Don Revis, a lawyer from Amarillo, was on the court. I was not familiar with him, but we had a good court, I thought.
Talk to us about the job of a Justice of the Court of Appeals. What was your daily schedule like? What was your mix of duties and responsibilities?
Well, the Court of Appeals is interesting in that you don't have discretionary jurisdiction. It's kind of like the trial court. If someone files a pleading, you're going to have to process it. Same way on the Court of Appeals. If someone files an appeal, notice of appeal, you're going to have to deal with that. It's with both civil and criminal jurisdiction. That was a little bit of a new experience for me, but it was interesting. And you receive a lot of help from your other justices there. But on the Court of Appeals, it's mainly taking those appeals and working through them. And it's pretty focused work. Each of the justices around the state, we equalize the dockets around the state. Supreme Court does that. And so each of the justices on the Courts of Appeals around the state will have ordinarily about 125 plus or minus cases to deal with per justice. And then you sit in panels of 3, so not only do you have the cases that you are writing, but then you are participating in another 250 cases. So each year you will hear or participate or review in 350 to 400 cases. It is focused and heavy-duty intensive work in my view.
So a little more than one a day.
Yes, and some of them are not so complicated, and then some of them are 20, 25-page opinions you have to write. So there's a lot to do.
And tell us a little bit about the role of the Chief Justice. How is that different from being one of the other justices on the court?
Insofar as the work you do legally, it's the same. You take the same load generally, and you do the same amount of cases. The problem is you also have the administrative work to do. You supervise the clerk's office, you supervise, you deal with employee problems, employment problems, you deal with budgets. You have to go, each of the courts of appeals has a separate budget in Texas. We fragmented it really well. Each of the courts of appeals has a separate budget, so when it comes budget time, you have to go to Austin and present your budget to the legislature and then shepherd that through. You also deal with the other courts of appeals chief justices from the state, Council of Chief Justices, that you try to coordinate how you do things. So you have the same workload, but then you also have administrative duties that can occupy any spare time that you might find.
You went from being a trial lawyer to an appellate judge. Were there any things you did to prepare for that new role?
Not really. I spent a lot of time as a trial lawyer reading those appellate cases and staying up with them on a regular basis. If you didn't, you were behind the curve. So the problem I had was trying to convert reading to writing. I knew what kind of opinions I liked for those judges to write and the justices to write. Now I had to try to do it. And it takes, in my case, it took 2 to 3 years to really start getting comfortable with that, to where you could make your opinions tighter and squeeze out all of the extraneous words, things of that nature. So it takes a while, and it took me a while.
Did you have any appellate judges who were your mentors during this process?
If you needed help, you could always go in and talk to someone else. Yes, so I would say mentors, the judges and justices that had been there and had done it. You always would go in and when you had a particular problem, and they were just open to helping you. John Boyd, Chief Justice Boyd, Justice Quinn had been there for a while when I got there. They were very helpful. One of the judges on the Supreme Court, James Baker, wrote opinions that as a practitioner I always liked, because they were fairly straightforward, fairly simple, not a lot of footnotes, and he covered and he was kind of a formulaic type. You knew the facts were coming first, and then he was going to set out the issues, so you could follow it real quickly. And I tried to model my opinions after him. I just thought it helped the bench and the bar to be able to pick it up and go through it quickly.
As an appellate judge, do you have any advice for practitioners to follow when they're preparing appellate briefs? State
your problems fairly quickly and succinctly, and don't get too involved with them. I mean, most problems can be, the more you know about any problem typically, the easier it is to simplify it, and the more conceptually you can present it. So don't get too wound up, and overcomplicate things, number one. Number two, don't stretch your facts and don't stretch your law. I tell people, we're going to read the record, and we're going to read the salient cases. We can figure out if there's a problem, and what you're doing is, when you stretch your cases or your facts, is you're not really helping us to get to the right solution. What you're doing is sort of building your reputation with the court. So be fair, be honest with the court.
What about advice for oral argument?
Same thing. It's be prepared, and I would say practice practice, practice. Good practitioners will do moot courts, go through those. You don't, in 20 minutes, you don't have time to cover your whole case. You have to prioritize. Of course, be ready for questions on those things that you don't think are the priority. But moot court, if you can get someone to sit with you, go through a moot court type process. 20 minutes goes pretty fast if it's going well, and it can be an eternity if it's not going well.
I bet that's true. What have you found to be the most rewarding aspect of being an appellate judge?
Well, you like to feel that you're contributing. You like to feel that you're making the law a little clearer so people can order their lives. That's, to me, what we're about. The law is about providing a framework for people to go about their business and, as much as possible, avoid getting involved in the legal system. Avoid lawsuits, get their affairs taken care of. And so, to me, you like to feel like you're doing that. You're helping the citizens of the state of Texas get about their business to the best you can by clarifying things.
What have you found to be the most challenging aspect of being an appellate judge?
Trying to get enough votes to come over to your side. The Court of Appeals, you only had to get one other justice to make it 3. We did not do too many en banc reviews in Amarillo. The Supreme Court, it takes 5 votes to get the opinion, to get the majority. So sometimes those other justices can be a little obstinate in their views when they're on the other side.
Do you have any particular techniques that you found to be effective in bringing people over to your side that you can talk about?
I really cannot. There are just no techniques. Quite frankly, I have confidence really in the other justices to deal with the case and draw their own opinions, and you just hope they land where you do. And if they're close, of course, then you have to work with those opinions to get 5 people, and 5 people don't always agree on the same things at the Supreme Court level. Same way on the Court of Appeals, to get one of your other justices, you modify a little without sacrificing principle.
Are there any categories of cases that you particularly enjoy handling, or any categories that you find particularly challenging?
No, I would say that the good thing about Texas is that we take them as they come in the door. We don't have judges who specialize in one case or another. And at the Court of Appeals, certainly you distribute those that way. And at the Supreme Court, we don't, they're not assigned. We don't have our cases assigned as they do at the U.S. Supreme Court. We draw for them, so it's kind of a blind draw, blind luck type thing. And some draws are good and some draws are not.
Do you have any other pointers or tips for appellate practitioners who might be practicing at the Court of Appeals level in Texas?
No, I would say, I think I've already expressed that. Practice, know your case, know the record. Courts of Appeals tend to be a little more record intensive on a lot of what they do than the Supreme Court. The record is, of course, important at the Supreme Court, but typically we're not going to take a case if you have a record problem there. So the Court of Appeals is typically more record intensive. You really have to know the record there. The justices are interested in that.
Let's talk a little bit about what you're doing right now. You said you were appointed to the Texas Supreme Court in 2005, and then you were reelected in...
In 2008, I was elected for a 2-year term. The way it works is you have to run in the next election after your appointment, and you run for the remainder of that term to which you were appointed. So I ran in 06 for a 2-year term. Then that was up in 08, so I ran in 08 for a 6-year term, then ran again in 14. So I've been elected to 2 6-year terms and 1 2-year term.
Tell us a little bit about the primary differences between sitting on the Texas Supreme Court and sitting on the Court of Appeals.
First thing is you have discretionary jurisdiction. The petitions for review take a lot of your time because we will ordinarily get 1,000 to 1,100 petitions for review every year. And those are not criminal cases except for juvenile criminals. So one big difference is I don't do criminal cases anymore except for juvenile crime. The other difference that I was going to go into is that with the petitions for review, having that many come in, and we can only handle usually 100 to 110 cases, maybe 120 well. So you're only going to get 10% that you can take. So deciding what you take is a big part of what we do. It takes probably, I would say, anywhere from 30 to 40% of our time spent on going through, reviewing the petitions, reviewing the briefs, then if you ask for full briefing, and then discussing the case in conference. So that's one really big difference. And then once you take the case, it's the cases tend to be a little more focused and a little more concept oriented than the ones in the courts of appeals, because you're pretty selective, and we have certain criteria that we use. So I would say that's the big difference. Another difference, interestingly, is in the Court of Appeals, we did not have so many outside duties as we do at the Supreme Court. Each of us on the court will have 5 or maybe 6 liaison assignments that we have. For example, I'm the liaison to the State Bar. I'm also the liaison to the Board of Legal Specialization. And we have Justice Guzman, who's the liaison to the Access to Justice Commission and the Commission on Children, Youth, and Families. And those are big jobs. They take you out of the court a great deal. They take up quite a bit of your time. So you're always at the Supreme Court trying to fight to get into chambers to work on cases. And the fact that we do it electronically now is just made all the difference in the world.
That's something I was interested in. I see you, and I also see Justice Hancock, who's in our inner court here at Texas Tech, with the iPads.
Right.
Doing all of your reading. Has that changed the way that you approach cases, that you are able to work on cases?
Well, it's not in your approach. Of course, the approach is the same, but it's made all the difference in the world to me. When I went on the Court of Appeals in Amarillo in 1999, it was all paper. And then when I went to the Supreme Court, we were still, in 2005, we were still doing paper filing, and then we adopted and mandated electronic filing. And once, once we did that, and I forget when that was, maybe 06, 07, we're going to tell the lawyers they have to file it electronically. I'm going to read it and deal with it electronically. So I just stopped getting paper. And that's been a transition. But as time goes by, it really makes a difference, because when I do have to travel, I can read things there. I can work on, a lot of times I go to a bar meeting or something, I can spend time, and the rest of the justices are the same, spend time back in your room at night working just right there through the VPN right there on your desk. Makes all the difference in the world in the ability to get your work done timely.
Have you seen lawyers do anything particularly effective for electronic filing that makes it easier for you and the other justices to do their work?
Yes. You can file your cases and you can embed your citations or your references to the record or to anything else, and it sure makes life easier for us if you can just, if you have a case that's been cited, a pinpoint cite, you just go click on it and you read and see what the lawyer says. And that's good and that's bad. But I think it's good because it makes lawyers make sure that the cites they give us are straightforward. They're not stretching their authority, so to speak. So that really makes a lot of difference, and especially also to the record, if you will embed those cites in your brief. That makes a lot of difference. And then having the record right there so you can go to it immediately without having to shuffle through paper. You can highlight. It all makes life easier.
Another thing that I'm always interested in is how judges use their staff attorneys or law clerks. Could you tell us a little bit about the staff you had at the Court of Appeals and the staff you have in the Supreme Court, and how you personally use them in your work?
Well, I expect staff to be an integral part of the process. At the Court of Appeals, I would have the staff attorneys typically work on one case at a time. Each of them would be assigned a case, and they would be a resource for me. Usually it was one of the larger cases that came in that I needed a lot of detailed knowledge about the record, and so we would work on those and they would help draft on it. But those were 1-year terms, and so those were, it was about the time your clerk got fairly competent, they were gone to somewhere else and you were into a new clerkship position. But that's the way I use the clerks there. At the Supreme Court, we use the clerks, I use them in a couple of different ways. I use them to help me screen the petitions for review and work with me on that. But then as the cases come in and we're assigned to cases, I typically will have each of my clerks assign one case, and then the staff attorney supervises them. And then they will ordinarily do a draft. Staff attorney will work on it, and then they will finally get it to me. And then as I tell them, I say, then I will mangle it and send it back to you. And so we work back and forth that way. But I think it's in my view, people come there to work, they want to be trained and they want to see how to do it. And they're good quality young lawyers, and they're entitled to that kind of respect. So that's the way I handle it. And the staff attorney there supervises those young lawyers and works with them, and it works out better that way because I'm in and out so much at the court, as are all of the other justices. We're just in and out. If the clerks had to wait to talk to us, it would really gum things up. So the staff attorneys are very important. We had 2 clerks in Amarillo. Then we would have one central staff attorney. Supreme Court, each of us has a staff attorney and 2 clerks.
If there's someone watching this video who's thinking about becoming an appellate judge, that's one of their aspirations, what advice might you give that person?
Same advice a senior lawyer gave me when I started. Said the first thing you do is you become a good lawyer. You focus on becoming a good lawyer. Secondly, become active. You have to be active in your community. Because we're in Texas elects their judges. You can be appointed if there's an opening, or you can be elected. Either way, it's in the political process. So become active in the community, not only because it's the right thing to do, but because you're going to need to be connected. And if you're going to be appointed, they're going to ask people in your community, what about John or Sally or whoever? Are they the kind of person that has the integrity, in your view, that we want on our bench? Secondly, become active in the bar, because you need to have feelers and relationships in the legal community, both locally and on a statewide basis. There are a lot of statewide organizations in the bar or sections in the bar you can become active in, always looking for help. You make a lot of good contacts that way. And so I think if you just go about developing a good, solid local expertise in the law, local community involvement, and then involvement on a statewide basis with the bar, that's going to serve you well when it comes time either to run, because you'll have supporters in the elective process, or in the appointive process, because the governor is going to make appointments, and the governor has supporters that he or she will listen to.
You said that you're the liaison to the Board of Legal Specialization, and you yourself were board certified. Do you think that's something that attorneys considering an appellate judgeship should be thinking about? And is it important that yours was not an appellate law, should they be thinking about appellate law as a specialization?
I'm not so sure that that's a criteria. I think for a while I was the only board specialized lawyer on the court. Now I think Justice Boyd is specialized. I think maybe Justice Brown is. So we have some other board certified specialists there. And I believe the only board certified appellate lawyer we've had was Justice Brister, who took the exam while he was on the court to become board certified. He was a civil trial specialist, but he took the appellate exam while he was on the court. So I would say it's not necessarily an important criteria. It's something on your resume, but not necessarily important.
I wanted to wrap this up by having you tell us a little bit about your family. I know you have a fantastic family. Carla is with you almost every time I see you, and I know she's been a fantastic partner for you in your career. And so let's talk a little bit about them.
Elective office is truly public service, and I think those of us that have been in it understand. And you're right about my wife. Carla and I have been married. We just passed our 45th year, and she's been a tremendous supporter. She was not enthusiastic about my going on the bench to start with, but she has been just a trooper about it all. Running statewide elections, as I mentioned, I've run 3 of those now. She's traveled the state with me. Many times after people say hello to me, they say, "So did you bring Carla with you this time?" So she has been a great supporter and an asset. I have 5 children. 3 of those are lawyers, 1 practicing here in Lubbock, 1 in New York, and 1 in Austin. The other 2 one's in the musical performance business in New York City, and one's been in oil and gas and is in that business over in the Dallas area.
And grandkids?
9 grandchildren. People ask me what I do for relaxing and enjoying. I say there's nothing to beat grandchildren. We enjoy that.
Well, Justice Johnson, thank you for being with us today and participating in the interview.
Thank you, Dean. It's good to be here.